I have to say I'm feeling very jealous of almost everyone in the room because I never knew Charles Reich. I encountered him as a newbie law student, first studying Goldberg versus Kelly, then getting a chance to read The New Property. And I remember to this day being immediately engaged by it. It was, to begin with, something miraculous to think that something that a law professor had written actually had any kind of impact on the world. That was encouraging, since I thought I might want to be a law professor. That was a plus. But also just the idea about the incredible vision of the individual and justice to the individual, and for using the law to better equalize power relationships was really inspiring. And at the time, I was also getting increasingly interested in administrative law, and so it really sort of intensified that interest in framing. And administrative law is still the lens that I want to discuss Reich's work today. But I have to say that over time, my view of the new property has become a little bit more complicated, maybe a little bit more shaded. And as a result of spending more and more time looking at the world from an administrative lawyer's viewpoint. It was a seminal article. And also the individual rights and social welfare. One piece I think Harold didn't mention, but the piece that also gets cited in Goldberg, was notably forward-looking in rejecting the right-privilege divide and the traditional distinction of government largesse as a constitutionally free zone where the government can do whatever it wants. I think equally important was what you call the, from the view of the beholder, but the idea of welfare beneficiaries as being of the same status, deserving the same protections that business beneficiaries did, rejecting that deeply entwined traditional disparagement of poor relief. And I think that his book, his article and his work really did have, as a result, a transformative effect on the law, on the administration of social welfare programs, we'll hear more about the specific cases and the adoption in Goldberg and then the development over time. At the same time, what does strike me about the new property, and this is the kind of shaded aspect, is how strikingly tied to the past it was, in both its diagnosis and its preferred remedy. The individual is the focus. That is not necessarily backward-looking versus forward-looking, but you see the government as a potential threat to liberty, discretion as the enemy. And as a result, the new property, I think, missed some of the key challenges and opportunities that administrative government presents or could present. And I think it also fed into longstanding anti-statist strain that continues to resist and oppose administrative government today. And so one of the points I want to make is I see some interesting parallels, despite their very different political commitments, between Reich's work and the conservative anti-statist attack on the administrative state that is in full flower at the Supreme Court today. I want to begin, though, by situating the new property in history, because I was also struck by Guido's point about him being out of phase. And when I was thinking about how to situate the new property in terms of developments at the time when it was published, maybe not when it was actually written, given what you said last night. So first, if you sort of take the perspective of administrative law at that time, the end of World War II brought enactment of the Administrative Procedure Act in 1946, and acceptance of and faith in administrative government under the APA strictures. You had the post-New Deal state in full flower. That was continuing through the early 1960s. You were beginning to see some cracks coming to merge, with some criticism about agencies being captured by the industries they regulated. It was a period very much dominated by economic regulation. This is a period, though, before we really get into the heavy social regulation and the environmental health and safety and consumer regulation that begins to happen a little bit later in the decade. The environmental movement is, I think, beginning to take hold. Silent Spring, I think, is 62. Is that right? So it's around that period, but not yet in full flower. So it's an interesting, from an administrative law perspective, it's an interesting time to write this because it doesn't sort of react to the development of the new administrative state. It doesn't really react to the flaws in the existing economic regulatory state. So a little bit out of phase in that way. It was a period of the civil rights movement. That was obviously a powerful force by 1964 when the new property was published. What I do find striking is that actually racism and racial equality are not a dominant theme in the new property. They do surface in the individual rights piece, but they're not really a dominant theme in the new property itself. You also are beginning to see concerns about entrenched poverty. Michael Harrington's The Other America gets published around this time. But again, the war on property really starts going more in a couple of years after. The welfare rights movement, which in some ways may have taken some inspiration from the new property, really takes hold more in 66, 68 era. So again, not quite in sync with those broader generations. What it does sort of follow, and I think were more important in terms of instigating the work, was earlier developments, in particular the anti-communism crusade of the 1950s, and the denial of government jobs, licenses, and benefits and the like to suspected leftists and communist members. And I think, Roger, in your piece, you've described how that harsh impact of that crusade was really brought home to Reich when he was clerking in Barsky, and that case that does feature in the new property. Karen Tani has written about how this anti-communism background factors into Fleming versus Nestor. So I think that definitely was part of the historical story behind the piece. But what's interesting is it comes at a point where that era has somewhat closed in terms of where we were politically, at a point where the state was about to be used for more progressive regulatory causes later in the decade and in the early 1970s in terms of more progressive social regulation. So again, kind of an interesting timing. So focusing on the core argument of the new property, it's very simple and it's very elegant, right? He begins by detailing the multitude of ways that individuals are both today dependent on government opportunities and other benefits. And he has a very evocative description. He says, hardly any citizen leads his life without partial dependence on wealth flowing through the giant government siphon. And he emphasized also that there was no going back, right? The expansive state was inevitable in our interdependent world. The alternative would be to transfer massive power to private hands. And instead, what he tries to do is to fashion a legal system that would work in this world of dependence, a way to preserve individual rights and liberty, and insisted that what we have to do is move from the traditional understanding of these benefits as largesse, that the government is free to revoke and alter as it chooses, to ones where they are now seen as individual property, the new form of individual property. And he believed that viewing benefits and opportunities from the government in this way would yield substantive and procedural constraints on government power. It would limit government discretion. It would prohibit conditioning benefits on sacrifice of constitutional rights or on irrelevant considerations. It would ensure opportunities for fairness, for hearings, for judicial review. Now, as I mentioned at the outset, I think you see here a really fascinating combination of conservative and radical moves. So the conservative move is turning to the traditional idea of property, right? Radical in exporting that idea to new contexts, and to a context that was traditionally seen very much in terms of politics and beneficence rather than one of right. Also radical in focusing on dependence and need as a source of rights. Instead of focusing on the reception of the new property, I want to focus on the images of the state, because here is also where I think you see a conservative edge to the work. And what I see when I read through the pages of the new property is a deep suspicion of the state and of governmental discretion. On his portrayal, the state is an entity that seeks to disempower, to exploit dependency. The state is a siphon, right? It's constantly expanding its power over individuals, both politically and legally. He describes discretion as intensifying that power, raising the risks of arbitrary and corrupt action, the need to cabin discretion, but also just to keep it at bay, to create spaces where the government was held out. And, you know, from my administrative law perspective, there is great truth there, but it is also a partial portrayal. Reich's own recognition of the need to regulate private power, I think, implicitly acknowledges that, right? The state that creates dependency is simultaneously the state that is empowering through creating opportunities, regulatory protections, the provision of services and benefits. Similarly, discretion can be arbitrary, but can also work very much to individuals' advantage. Greater flexibility can allow greater tailoring to need and circumstance. And one of the criticisms of the transformation and welfare programs over time, one made forcefully by my colleague William Simon, is that one of the effects of turning against discretion was that it actually then prevented professionals and other in the welfare establishment from using their expertise in ways that actually would have helped, instead created a more rule-bound system. Obviously, one can see pluses and benefits in both of those, but it's an interesting way to understand that discretion is not necessarily always a bad thing for individuals. And in particular, recent scholarship on administrative constitutionalism works both by Karen Tani, by Sophia Lee, by others, have emphasized the ways that administrative officials actually employ discretion to expand individual rights. Another way of dealing with the dangers and the reality of the expansive state is to work at it from within and to use those very tools of government discretion and expertise and power in a more individual informing way. I think you also, it's also very informative how he frames administrative context. So he focuses, this is again your idea about the reception, right? So he focuses on the interaction between the government agency or official and the individual who is subject to that agency and official's action, right? And insisting that that perspective of the acted upon come to the fore. What's interesting is that there's a multitude of other parties that are excluded from that framing, right? Regulatory beneficiaries, other program participants, a whole range of third parties. And I was really struck, there's one example where he talks about how the government required universities and other institutions to gather information on the number of blacks employed in each department as a condition of grants. And Harvard University had resisted this, saying, by having to count how many blacks are employed, that is forcing us to impose that racial identity in exactly the way we don't want to in our community. Certainly a valid point, one that is part of discussion today, but there's also a counter view, which is the need to sort of gather information, to change mindsets, to bring attention to what are often then hidden problems that don't get light. And there's no reference in Reich's description of this example of the third parties, the individuals who might have been being excluded from opportunities who would benefit by such information. There's really only description of its harm. So this is what leads me to have as I said, a slightly more shaded view. You can't just see this as the public interest. He does talk about it as the public interest state, but the public interest in these cases, these other parties that are involved, they're actual individuals. The complication, of course, of regulatory actions and actions by the state and government programs is that they are deeply polycentric undertakings. And so to simply focus on one who is acted upon by the state loses, I think, that broader context. Now, it's actually, you mentioned Jerry Mashaw, and Jerry Mashaw is one who really sought to draw both on Reich, I think, but also to draw on the administrative perspective, the view that would take into account a broader systemic and administrative approach to due process, what he called it sometimes the managerial perspective. And there may be overlap with the perspective that focuses on the acted upon individual and the perspective that focuses on the managerial view. From both perspectives, for example, there are benefits of clear and consistent rules for fairness, but it's a different view. And it's a view that may elevate certain programmatic aspects over just the view in the individual. Or to put it differently, maximizing fairness and gross may at times lead to unfairness in specific cases. There's, I think, always going to be some trade-off there. So in thinking about why Reich framed so much around the individual, I think it was very deeply his worldview. And that was how he related and understood the dangers of the state. But I think that instinctual feeling about the state does relate to this kind of traditional anti-statist idea that crops up and has cropped up periodically, runs very deeply in this country. Even as what's fascinating about Reich is that even as he acknowledged the need for a more active state, the fundamental relationships of interdependence that characterize us today, his suspicion of the state, that anti-statist suspicion, also came in to play at the same time. So let me jump forward a little bit to today and to see if I can explain why I see a parallel to some of the attacks on the administrative state that are at the forefront of the Roberts Court. There are many components to these attacks, but one of their striking features is a very strong rhetorical condemnation of the administrative state. Chief Justice Roberts is really prime among this. He has the most evocative imagery. He describes bureaucrats prying into every corner of daily life. He has analogized administrative government to maybe it's not quite tyranny, but it comes close. Administrative officials are described as biased and abusing their powers to their own advantage. There's an equation with the government with nothing more than a private party having the same kind of biases. Now, there are some very important differences between the articulation of the anti-statist view and anti-administrative view of the Roberts Court and Reich's vision. To begin with, and I think this is a very important difference, the Roberts Court antipathy is more libertarian and anti-regulatory. It lacks Reich's concern with private power. It is animated, I think, by a desire for a less active state. It's clear that the politics of Reich and the politics of the justices, the current conservatives on the court at least, were quite different. You also see an interesting move in the Roberts Court today to reassert the very divide that Reich sought to undercut. So you have a growing emphasis on the difference between public and private rights, which has very close overlaps to the distinction between rights and privileges. And you have the Roberts Court emphasizing that it is traditional private rights, which they describe as the stuff of traditional actions at common law tried by the courts of Westminster in 1789. That is their focus, and it is their focus also for judicial protection. So they, in that way, they actually are re-emphasizing the distinction between government largesse and those traditional private rights that Reich tried to overthrow. They are also particularly concerned about protecting judicial power against administrative intrusion. It is protecting the individual's access to independent judgment in courts rather than to fair procedures writ large that matters. I'm actually not sure, and I'm curious to know what people think about this, how much of a difference that is, because there is a way in which you see courts coming in as the protectors of fair process, as individual rights enforcers, in Reich's vision as well. So I'm not sure if the turn to the courts is totally opposed to his, but he certainly was more interested in constraining the state writ large and from fair procedures on the state and not just the court. This focus on the court of the Roberts Court also means that it's not as concerned about discretion per se. It's concerned about administrative control of law. So when you have discretion on a matter that the courts think of as just policy, they're all fine with that. And just look at the census case from last term, and you see these very broad willingness to defer to what were clear, in my view clearly, but certainly very much at the border, arbitrary exercises of policy by the government that they were fine deferring to because they decided there was no law involved. That very insistent on a formalist distinction between law and policy, by the way, I think is another significant difference from Reich, because I see in his understandings much more of a legal realist recognition that property is a constructed category, and we can move the goalposts about what counts as property, whereas you see much more return to a pre-New Deal formalist distinction between law and policy today. So there are many distinctions. This is not to say these are clearly equatable on all fours at all. But what you do see in these opinions is a presentation of the administrative state as a fundamental threat to individual liberty, and on a need to transform doctrine in response. And just as Reich turned to the traditional concept of property to provide that protection to individuals dependent on the state, these attacks invoke and invent as well this role of the courts as playing that same role in terms of constraining administrative power in defense of the individual. So just take as an example, and I'll close about just describing these two cases from last term, one called Kaiser versus Wilkie and the other one Gundy versus the United States. So Kaiser involved the case of a veteran who was a Marine in the Vietnam War, had been involved in a terrible assault. The Marines had been wiped out. He suffered from PTSD. He had applied for veterans benefits for disability in 1982, was wrongly denied, case didn't go forward. Then he later got a diagnosis of PTSD, which had been denied before, reapplied for benefits, and was granted benefits, but they weren't retroactive. And the case, as it was presented to the court, was really an administrative law question. It was how much do you defer to the agency's reading of the procedures involved in making the claim that the benefits should go back in time. And so it was really the doctrine of deference to administrative regulatory interpretations that was at issue. In Gundy, Gundy was a sex offender who had served his time in prison and was then subject to the Sex Offender Registration Notification Act requirements. Because he had been convicted before the SORNA Act had been enacted, he was one of these prior offenders, and the question was, how will that act apply to those who were convicted before the act went into effect? And the act delegates that question to the Attorney General. So Gundy comes up as a challenge to the delegation of this authority to the Attorney General, and also as a broader attack on delegations writ large. Now, in both cases, the court ended up affirming some deference to agency regulatory opinions and affirming that this was a constitutional delegation. But there are very strong dissents by Justice Gorsuch in both of these cases, essentially dissents. And in many ways, you could cut and paste those dissents into the pages of the new property, I think. So at the core, they are really calls for recognition of the dependent and disempowered individual at the mercy of an omnipotent and arbitrary state, offering very dire warnings about the threat to individual liberty that agency deference and broad delegations will pose. If you look at the new property, there is arguments for narrowing delegations of authority in a very similar vein. And so I think, I find it fascinating that we have this cyclicality in administrative law, but I think there's an interesting parallel there. And in some sense, I think there may have been a lost opportunity because the one part that we haven't managed to do is to try and come up with arguments that give a constitutional requirement of using state power, accepting the state, and using state power in more individual affirming ways, which I think if you have a frame of an individual opposing the state are harder to articulate and justify. Thanks very much.